may I welcome you to another video seminar on aspects of the law relating to fire. Can I say what a privilege it is to once again be in collaboration with the Fire Protection Association. Red Line Chambers and the Fire Protection Association have a long history of seminars relating to fire law. Can I also say what a privilege and pleasure it is to today be interviewing my friend and colleague, David Claxton, who is a key member of the Red Line Chambers fire law team. David, welcome. I understand that you have a background in a range of regulatory matters.
Thank you, Sailesh. It's very nice to be in conversation with you too. It's right to say that I practice in fire law as a specialism within general health and safety, which I also do, which forms part of a more general practice of representing businesses and business people in relation to regulatory and criminal enforcement and investigation.
And I think you represent not just companies, but company directors and advise as well as represent in court.
Yes, that's right. So the whole gamut of businesses, from the companies themselves to their directors insofar as they have obligations or incur liabilities, is a result of their status as directors and officers, as well as individuals in their own private capacity, unconnected with businesses. But the common theme in all of these cases tends to be that the criminal or regulatory action has some connection either to membership of a profession or to the running of a business.
David, I think you've been involved recently in an important fire law case involving a company and its director.
That's correct, Sailesh. It was the prosecution by Suffolk Fire and Rescue Authority of a company called Home From Home Property Management Limited and its director and primary shareholder. And they were, and still are, a property management company with a large portfolio of companies and properties that they operate for in the East Anglian region. And this case was principally, although not exclusively, concerned with the sufficiency of the fire risk assessment as it related to ACM cladding.
And is it unusual in your experience for the prosecution to pursue a management company as opposed to other duty holders?
It is unusual, but I think it may end up being more commonplace. And it's simply a function of the way in which the fire safety order is structured and the way in which the obligations can be delegated. Here, it was a block of flats called Ipaxis, and there was a company that was incorporated in order to essentially hold the residents and the property owners' interests. And so they were the responsible person, but they engaged Home From Home to deal with all matters relating to fire safety, which meant that under Article 5.3 of the order, Home From Home was the duty holder. And so whilst they had a shared responsibility for fire safety responsibilities, one as the responsible person and one as the duty holder, in terms of their private contractual arrangements, the primary responsibility for fire safety and the reason for which Home From Home had been engaged and were being paid was to deal with matters for fire safety for the building.
And why was the prosecution interested in pursuing the director of that company as well as the company? Because presumably the contract or the relevant contract was between a company and the residents.
Yes. I think there's two answers. One is legal and one is practical and to do with particular circumstances of the case. It is the case across the regulation of businesses, and it's not just a health and safety or fire safety specific topic, where if a company commits an offence, and if that offence is caused by, for example, connivance or neglect by a director or officer, then that director or officer also commits an offence. And it's a way of ensuring that those who are truly responsible, in the sense that it is their acts or omissions that bring about the circumstances complained of, don't escape criminal liability simply because they're operating through a company. And that's part of the rationale. I think the other part of the rationale is that fire safety prosecutions are by their nature rare, and they're an important part of how a fire service signals to the community it operates in the way in which it takes fire safety seriously and to some extent attracts attention to fire safety issues. And I suspect that the analysis in this case was that it was just and proportionate to prosecute both the company and the director, but also that it was consistent with their wider public duties to do so.
And this was a prosecution involving a fire risk assessment. Is that a sort of fairly new trend? Because my experience is that historically, companies or individuals who have created a risk assessment rarely get prosecuted, partly because the standard is not well defined.
Yes, I think that's right. And maybe this case wasn't as much of a departure as it would appear, because it wasn't Home from Home who had produced the fire risk assessment in question. They'd gone to an external fire expert, and there was no question or challenge to the quality and experience of the fire risk assessor. The issue was the information that he had been provided by Home from Home. Fundamentally, it came down to whether or not there had been a fire engineer analysis and report on the cladding and what they'd assessed the risk as having been. In fact, they'd provided a scoping report, but it was no more than a one-paragraph email that said that the risk was high and that they could, if commissioned to do so, produce a full technical report. But when the information was given to the fire risk assessor, he was told that there had been a full technical report and that the information provided was that the risk was low. And so the shortcoming in the fire risk assessment wasn't the fault of the fire risk assessor, but of the client who deliberately, so the prosecution said, provided false information.
So there was cladding outside the building that was dangerous and had been tested and was proved after the testing to be dangerous. But the management company...
It was in the immediate aftermath of the Grenfell Tower fire, in the middle of 2017. As with many clad buildings, a sample of the cladding was sent off to the high-rise coordination group in the BRE, who assessed it, tested it, and reported back that it was a Category 3 failure. Interestingly, it wasn't mandatory at the time, given the height of the building, to have sent the cladding off for testing. But the decision having been made to do so, and the information being what it was, namely that it was a Category 3 failure, that plainly had to be reflected in the fire risk assessment.
And so what should the management company have done in those circumstances that it didn't do?
Well, I think it's important, Sailesh, to delineate what was within their powers and what wasn't. Certainly they didn't have the resources or the power of their own volition to remove the cladding or to initiate the steps that would ultimately lead to its removal. But they should have, in the first instance, told the fire risk assessor of the fact of the failure, because he then could have assessed what the associated risks were. For example, was there a problem with other cladding on the building which wasn't ACM but was terracotta, and was there a potential for the two to interact with one another? It would have had an effect on the placing and the extent of fire alarms. For example, if you have a building that has combustible cladding on the exterior, you would ordinarily have a fire alarm within a residential flat as close as possible, if not on, the affected wall, in order that it's situated in the position it will be most efficacious in terms of picking up the fact of fire. And that was part of what had happened in this case, because the management company unilaterally changed from a shelter in place or defend in place, stay put response to fire to simultaneous evacuation, which wasn't necessarily wrong. But in order to have a simultaneous evacuation, you have to have, for example, a fire alarm which operates so as to support it. And the automatic opening vents on the fire alarm system have to be programmed so as to protect it. And there has to be information and training of the residents to know that, in fact, that's what's in place, a simultaneous evacuation procedure, and how to go about it safely. And so the prosecution concerned not only the fire risk assessment, albeit that was the main and the lead allegation. There were secondary counts on the indictment concerning the suitability of the fire alarm for the type of evacuation procedure in place, the programming of the opening vents, and the lack of any suitable drills or other preparations for that style of evacuation.
So there are a number of technical aspects that you had to get across to the jury, ranging from the law on fire, to evacuation, to fire alarms, etc. How does one get across these technical aspects to a jury composed of 12 ordinary men and women who would know nothing about this area?
Well, I think that after I've answered the question, I'll be interested to hear your perspectives on it as well. But I'm sure you'll agree that it's our job as barristers, as we do regularly, to take these complicated subjects and to express them in a simple way and to find the right witnesses to explain them and to take those witnesses through their evidence in a way which is understandable and digestible. For all they are technical subjects, I think they're interesting to a jury because everyone's affected by the risk of fire. I think they are obviously important because everyone's concerned at the potential from the risk of fire. So one has a slight advantage compared to other dry technical subjects that might arise in health and safety cases, in that there's a natural interest in the subject. And I think maybe this is also part of your experience. For all the subject matters are technical, all aspects of fire safety are inherently logical. So, for example, it's logical that if you're going to have a fire risk assessment and its purpose is, I paraphrase slightly here, but to identify fire risks in order that they can be managed, mitigated and understood, that has to include the fact that you've got combustible material on the exterior. That's quite common sense. Once you explain how an automatic opening vent works and the fact that it's supposed to produce a chimney effect, it then becomes quite obvious that a chimney will only work if it's closed, other than at the point at which the smoke is entering. And so my sense in the course of this trial was that though we were traversing some fairly technical territory, there was no point at which the jury didn't understand what it was about and what the relevance of it was. And fundamentally, because all of these offences require this as an element of them, why it gave rise to a risk of death or serious injury in the event of fire.
And I suppose it's that risk of death or serious injury that would have made the jury think hard and focus hard on this case, particularly so shortly after Grenfell fire.
I believe so. Yes, I think that must be right.
And
in your experience,
one...
sorry, forgive me. I was going to say, just in your experience of presenting fire safety cases to a jury, do you find that it's a challenge to overcome the technicalities and to explain them, or do you have any particular ways in which you like to go about doing it?
Certainly, the starting point of any trial is that the jury get their summons and they come to court on a Monday morning hoping that it's a murder case or at least a juicy pub fight that they're going to be adjudicating upon. And when they're told this is a fire case, you can sometimes almost see that their enthusiasm wane. But my experience is that when a jury is told how important a case is, particularly when there's death or serious injury that is being alleged, then they appreciate the importance of the task. And then I find that there's an about change in their approach. And I've so far never come across a jury that hasn't been engaged in a case like this, whatever their initial response. But as you said, it's part of the job of the advocate to not only make it interesting for the jury, but to explain to them the importance of a case. Because sometimes you may have, as one of the counts on indictment, a door, self-closing door that's not closing properly. And without the knowledge of how dangerous that might be in a fire and how just one door that doesn't close properly can result in the spread of lethal smoke, and therefore multiple fatalities. Without that knowledge, of course, a jury would be forgiven for wondering why on earth the poor defendant's been prosecuted for a door that's not self-closing. And so part of the job, of course, is to explain how absolutely serious it is. And of course, it becomes easier, I think, post-Grenfell, because people are much better informed about the importance of fire safety.
Yes, in terms of explaining that matrix where you have the risk that's produced by a particular set of circumstances and the associated danger from the perspective of death or serious injury, and also the nature of the fire safety breach itself. In your experience of prosecuting these sorts of cases, do you usually have an expert witness to assist a jury, or have you managed without one?
My first option in an ideal world is to have an expert. Partly an expert to say that in these circumstances, or the combination of these circumstances, the combined effect of them is that there is a risk of death or serious injury. And also to explain some technical aspects, for example, the stay put procedure and why that should have changed to instant evacuation, or a particular type of fire alarm being the incorrect sort. So my ideal is to have an expert. But David, I think in your case you didn't have an expert.
No, we didn't. And it was plainly one of those subjects that was weighed carefully, because there's always going to be, whether they're strictly necessary or not, some advantage in having an expert, in that there is someone who can explain, by reference to their own opinion, how the fire safety arrangements should work, how they in fact did work, and what the consequential risks were. And perhaps for the non-lawyers who might be watching, it's worth explaining that an ordinary witness is confined to giving evidence as to what they saw or otherwise observed, or what's otherwise within their knowledge. They're not allowed to express an opinion, and the difference with an expert witness is that they are permitted to assist a jury in understanding the issues by giving their opinion. And so it's always easier if you're not constrained in that way, and if you can give your opinion.
And of course, rarely, fire law is one aspect of that rarity, is that the expert usually is not allowed to comment on what's known as the ultimate issue, which is for the jury. But often in fire cases, the expert is entitled to say, in his or her opinion, that the combination of these factors do result in a risk of death or serious injury. And so that's an added bonus if one were able to have an expert.
Yes, I think there are also some downsides to experts, in the sense that they elongate the proceedings and they add cost, and they can sometimes make the cases harder to be listed. One has an expert who often is very busy to factor in terms of availability, so you can wait longer in order to have a longer trial, which has all sorts of unwanted effects. And it is sometimes the case that though an expert is there to assist in understanding the issues, the case can become a battle between experts, and the personality and the presentation of any one individual expert can become the case defining feature in circumstances where there is a whole welter of other evidence which is just as important. So I'm a little wary sometimes about engaging experts unless they're strictly necessary. But you certainly go into a trial with an advantage if you have a good one who can explain the complex in simple terms.
And I think in your case, the defence didn't have an expert either.
No, it was an expert-free case, although there was lots of technical evidence, and we were able to some degree to get around the absence of an expert, if such a thing were necessary, by, for example, reference to the Article 50 guidance, which has a statutory status, and so it's admissible, and it's relevant as long as it's the appropriate guidance. And of course, in the context of cladding, there were a succession of departments for communities and local government guidance that were being periodically issued across the period that we were concerned with, and they culminated towards the end of the indictment period in consolidated guidance. So the technical background was capable of explanation, partly through the published applicable and admissible guidance. And we had highly expert fire officers within Suffolk Fire and Rescue Service who, whilst not called as experts and not expressing their opinion on anything encroaching on the ultimate issue, were able to explain how fire safety arrangements work, what arrangements should be in place, and the sorts of things that in their experience can result when the fire safety arrangements aren't as they ought to be.
And in your experience, David, is that a fine line that fire officers, particularly senior fire officers, tread when giving evidence? In that on the one hand they're witnesses of fact, but on the other hand they're witnesses of fact in particular circumstances, which of course they're viewing through their experienced eyes.
Of course, it's a fine line, and it is sometimes a movable line, because whilst as lawyers we can all reach a view on what the limits of non-expert evidence are, or indeed sometimes what the limits of expert evidence may be. In practice, in a trial, it's a dynamic process where you have the factual circumstances the nature of the evidence which is encroaching towards the expert territory, the tolerance or otherwise or attitude of the defence and the extent to which they want to seek to limit prosecution evidence, and then the particular attitude of the judge, because rulings on these things aren't always black and white, and there's a range of reasonable judicial responses, and so you can go into a trial sometimes not with the certainty that you might want as to what the extent of the admissibility of the evidence that you want to call is going to be.
Yeah. And has your trial concluded, David?
The trial has concluded, but the sentencing hearing is scheduled for the end of July.
And can I ask, why was this case in the Crown Court? Was it the prosecution who chose elected Crown Court trial, or the defence?
The defendant elected a Crown Court trial, as was his right, with the consequence that the view of the prosecution became irrelevant. It was always going to be a jury trial in those circumstances. I do think, though, that with increased fines available, so that's another factor. When this case began, the law hadn't changed in relation to maximum fines, albeit it wouldn't have necessarily affected this particular set of offences. But now that the fines are largely limited across fire safety offences, there is likely to be much more willingness on the part of magistrates' courts to hear cases. And I was appearing very recently in a health and safety executive case in front of a district judge who said that, and it was a fatal accident that historically would have always been a Crown Court trial. And the district judge was quite enthusiastic about retaining the case in his own jurisdiction.
I was last year prosecuting a very large company with a £2 billion turnover, where the common view between prosecution and defence was that the sentence would be upwards of 5 million, possibly 10 million pounds, and the district judge was insistent on keeping the case in the magistrates' court. And it was only because we were able to point to a judicial direction from the Lord Chief Justice that persuaded the district judge to let the case go to the Crown Court. So I agree. I think more and more cases are likely to be kept in the magistrates' court unless there's good reason to go to the Crown Court. Can I briefly come back to a point in your case related to fire risk assessments? What's your opinion generally on risk assessors and their liability? I appreciate in your case you weren't prosecuting the company that actually carried out the risk assessment.
My personal opinion is that there is a great deal of variance of quality and assiduity across fire risk assessors, and that frankly it is, as things stand, an unregulated profession where anyone can hold themselves out as a fire risk assessor and anyone can perform fire risk assessments. Of course, they take on duties under the fire safety order when they go out and work and do fire risk assessments, and so they're not wholly unregulated in that sense, and one can easily imagine a deficient fire risk assessment resulting in prosecution in the right circumstances. But that would require a fairly rare combination of circumstances where a fire service has occasion to look at a fire risk assessment and is in possession of sufficient information to contradict or to show that it's deficient, and then to take the decision to prosecute. So I think there is that threat that exists, but it is likely to be exercisable so infrequently that it's a very limited deterrent effect for those who ought not to be performing fire risk assessments. There are, of course, non-mandatory qualifications that can be obtained, but those don't always, again, guarantee quality, although they'll often be a hallmark of some sort.
In the recent past, I did a similar seminar involving Colin Todd of the Todd Associates, a fire expert, as well as an ex-commissioner for the London Fire Brigade. And the common view was that ideally should be some greater regulation, because there are a number of very good companies who do fire risk assessment, but it's difficult to control the profession of the cowboys who will do the poor risk assessments. and so this may be an area that's ripe for either legislation or voluntary code of conduct.
I think it is ripe for something. If it were legislative, the danger is that the regulator creates a standard that's relatively easy to satisfy, and that it creates a false reassurance. I tend to think that a voluntary code is probably a better measure, because it's likely that only those who are truly skilled in the relevant area would volunteer, as opposed to having to, and there being a somewhat artificial set of criteria, as is always the case with any regulated professional body.
David, in the 3 or 4 minutes we have left, can I just turn to the end of your case? I appreciate that you haven't got to the sentencing stage yet, but what are the broad areas that one should consider, whether prosecuting or defending, when it comes to sentencing in a case like the one you've just completed in front of the jury?
In the sense of the relevant considerations that apply. When you're dealing with a company, the first and the most consequential determinant of a sentence is going to be the means of the company, and that's principally a function of turnover, but it's also the net asset position, profitability, and various other financial factors. So one always has to look at the finances of the company, and ordinarily a company would be ordered to disclose its annual accounts for the previous 3 years. Sometimes, depending on where a sentencing hearing falls in a company's financial year and the date by which it's required to produce its accounts, because that obligation doesn't always arise until 9 months after the end of that financial year. You can have a situation where the properly provided up-to-date financial information is not in fact up-to-date at all, because many months or more than a year has passed. And so I'm sometimes sensitive to the need for interim accounts or some interim financial position, just so that changes in financial fortunes aren't overlooked. So that's the main thing. Otherwise, you would be looking at whether or not the work that ought to have been done as at the date of the offences has since been done, the level of cooperation with fire services, with other investigations, and whether or not any actual harm resulted, how long the state of affairs that gave rise to the offence persisted for, and things of that sort. Because a first offence by a company which had good intentions but on a given occasion found that those good intentions fell short, but on having that pointed out to them quickly and without complaint put things right, goes into a sentencing hearing in a very different position from one that has put cost before safety, has allowed a dangerous situation to persist over a long period, and has sought to evade liability in all sorts of different ways over a prolonged period. So far as the company is concerned, those are the considerations. So far as the individuals in fire safety cases are concerned, one looks at the sorts of things that are common to all sentencing of individuals, such as their personal circumstances, their individual culpability, the reasons behind their offending, their attitude to it, their own efforts at putting things right, those sorts of things.
David, thank you very much. It's been an enlightening discussion with you. We wish you the best of luck at the sentencing hearing as well. Just in a final word or two from you, what are the key takeaways from the case that you've just finished?
Thank you, Sailesh. It's been a pleasure to have a conversation with you about these subjects. For me, the key takeaways are the importance of a focused indictment which fits within a story which can be readily told to a jury. So here we had the fire risk assessment, which, as I've described it, was the lead offence, but it had a connection to those other offences as well, because the fire risk assessment is how you would determine what was the appropriate evacuation procedure. Fire risk assessment is how you would decide, by reference to that evacuation procedure, the sufficiency of the fire alarm, whether or not the operation of the vents is working correctly, whether or not there's been sufficient training and drills and so on. So I think the key takeaway is that it's important not just to pick a random selection of fire safety breaches, because there are many of them in the order, and where there is one, there are often lots in a building, but to choose those that are part of a coherent narrative which makes the prosecution case understandable and, insofar as it can be, appealing to a jury.
David, on behalf of the Fire Protection Association and Red Line Chambers, thank you very much. It's been a pleasure.
Thank you, Sailesh.